Good morning, everyone. Happy Webinar Wednesday. It's great to be back here and welcome to PRLA's Industry Update webinar. My name is Zach Pizek. I am PRLA Senior Director of Public Affairs. I'm joined by my colleague, Lauren Brinjack. Lauren?
Hi, everyone. Zach said I'm Lauren Brinjack, Senior Director of Legislative Affairs for PRLA, and thanks so much, everyone, for joining us today.
And we are here today to discuss and potentially help answer some questions regarding one very specific topic for this Industry Update webinar, Act 51 of 2023. House Bill 1160, which was a 2023 PRLA legislative priority and championed by Representative Nelson, passed both chambers last year, the first year of the legislative session here in Harrisburg, and was ultimately signed by Governor Shapiro in December. The core intent behind HB 1160 and now what is Act 51, as many of you know, was to expand the provisions allowed for by Act 81 of 2021 as it relates to off-premise catering permits. Those items, too, back in their original form, were introduced by Representative Napoleon Nelson in 2021. When it comes to off-premise catering permits, pre-COVID, OPCP holders were limited to hosting just 52 events per year. The General Assembly, due to Representative Nelson's leadership and stakeholders' engagement, decided to get rid of that cap and ultimately allow for unlimited number of events as a way to provide relief to the industry during the pandemic and mitigation. What we realized then is that it wasn't just a great move because of the relief that it provided to the industry, but it was also just a great move, generally speaking, for the Commonwealth. It allowed an expansion of opportunities for our members and the operators we represent, but also an expansion of services that can be offered by nonprofits and other organizations regarding catered events all throughout the Commonwealth. Also brought in a significant amount of revenue for the Pennsylvania General Fund. Due to efforts of PRLA members like Jeffrey Miller from JAM Catering and the rest of the catering community, and so many of our restaurant partners, and also, of course, due to Representative Nelson's leadership, we were able to make permanent the idea of hosting an unlimited number of events. I often joke with my wife and friends, though, that a lobbyist helps write and draft laws when we can, but it's ultimately lawyers and judges that are the ones that help interpret those laws. And I'm not a lawyer nor a judge. And so PRLA did want to invite some lawyers to join us to discuss this legislation and to address some of the changes around off-premise catering permits in general. So in a moment here, I want to introduce everybody to Daniel and Evan from the Tucker Arensberg team, who have generously offered to join us to discuss this issue today. Many of you might have seen a recent brief published by the Tucker team on this issue. I want to say either back in 2023 or the start of 2024 here, but we did circulate that with our membership. That was very helpful. And so I want to check here real quick to see, I know Representative Nelson plans to join us as well, just to say a few words, and then I also want to turn it over to the Tucker team. Representative Nelson, I know you have a busy day in Harrisburg, but is now a good time for you to jump in and say a few words? Thank you for your leadership on this issue.
Sure. Listen, it is an absolute pleasure to support and to partner with you guys. Thank you for the shout out to Jeffrey Miller, who is a wonderful caterer, got a great operation in my community, actually around the corner from my house. And so I'm looking forward to both working with him, working with you guys, and most importantly, just making sure that we are providing those in the restaurant, catering, and lodging industry all that they need to make sure that we can put COVID behind us. We can understand a little bit about what we learned from COVID that we should continue doing even now after the pandemic, and how we can make sure that, again, that business is alive and well, but also that we can celebrate once again. I say it over and over again when I make public comments about this. You guys in this industry are the ones who are there for our greatest moments. You guys are there for our weddings and our anniversaries and our sweet 16s and quinceañeras, and you guys are the ones who celebrate with us when we retire. And you know, unfortunately, as you guys know, we like to party. So thank you all for being there and supporting just the 13 million residents of Pennsylvania as we just look to celebrate those moments that take us away from politics and take us away from the grind and allow us to make core memories in our lives. That's what you guys do, and that's what makes this easier, so much easier for me to advocate, to champion, and to be along for the ride. Thank you guys for the work.
Thank you, Representative Nelson. And like I noted, without your leadership, this wouldn't have happened. And so we really appreciate all you did for the hospitality and tourism industries, and all you continue to do for not only the industries we represent, but all of Pennsylvania. It was a real privilege to work alongside you and your staff and your team on all of this as you navigated this moving forward. And with that, I would love to turn it over to Daniel and Evan from the team at Tucker Arensberg. Daniel, Evan, thank you both very much for joining us today. Lauren and I will monitor questions that come into the chat for PRLA members on the call. Feel free, if you have any questions throughout the presentation, throw them in the chat. And we'll reserve some time at the end for Q&A. Without further ado, Daniel, Evan, floor is all yours.
Thank you, Zach. Well, as Representative Nelson says, people in this industry do like to party, and I think that we have a lot to celebrate because of this recent legislation. So Evan and I are going to be getting into the nuts and bolts of what these changes mean for the industry, for people in the industry, and how licensees can actually make use of these off-premise catering permits. So just before we get started on our presentation, I just want to introduce myself and tell you a little bit about my firm. I'm co-chair of my firm's hospitality practice group. Tucker Arensberg has 6 offices. We have one in Harrisburg, which is where Evan's at, and one in Pittsburgh. We have 88 attorneys firm-wide. Our hospitality group focuses on providing services on liquor licensing, licensing compliance, labor and employment, corporate work, intellectual property, real estate, and if there is a need for litigation, we have a very fine team of litigators as well. I think that's what's unique about our firm, is that we're able to bring people who have deep expertise in each of these areas, but that also know the client, know the industry, right? So I think it's different to be able to, there's a lot of real estate lawyers out there, but to be able to talk to a real estate lawyer who knows the industry, I think is important. So Evan, I'll give you some time to introduce yourself and Harrisburg.
Thank you, Daniel. And good morning to everyone who is in attendance. My name is Evan Pappas. I'm an attorney and shareholder here at Tucker Arensberg. I'm the other co-chair of the hospitality practice group, and I represent a wide variety of restaurateurs as well as manufacturers in licensing issues, disputes, issues with the PLCD, real estate issues, and increasingly intellectual property issues with restaurants and breweries, wineries, et cetera. So my practice is one of sort of a general business representation with a particular emphasis on hospitality businesses, both hotels, restaurants. So, we do have sort of a broader periphery of issue spotting capabilities, I guess you could say, when it comes to your industry. Restaurants are small businesses like any other, with some very niche and unique issues that they have to deal with. And we feel we have that capacity. So we're glad to be here this morning. Thanks for having us. And I'll let Daniel give the first introduction to the catering permits.
Yeah. And Zach, I just wanted to tip my hat to the association. The PRLA did an amazing job and really kind of spearheading and working with Representative Nelson and then other members in the legislature on getting this piece of legislation through. So thank you for all your hard work. Let's start off here with what is an off-premise catering permit. I want to I think a good place to start is what the definitions, right? It takes me back to my first year of law school when my law professor said, you know, the rules, there's 3 rules of statutory interpretation. Rule number 1 is read the statute. Rule number 2 is read the statute. Rule number 3 is read the statute. So we'll start with that. And I'll give you the definition for what a catering event is as written in the statute. And I'll emphasize since now that this is a catering permit. There is no such thing as a catering license. I think that there has been some confusion out there. I've talked to a couple of clients who have called me and said, I'm ready to apply for my catering license. So, you know, I have just a catering business from my home and I'm looking to sell alcohol, you know, in conjunction with my catering business. And I say, well, you have to slow down here. This is a catering permit that is associated with existing restaurant licensees, hotel licensees, eating place, and brew pubs. But here's the definition of a catering event. Eric, if you could please go to the next one. A catering event, and I'll just read it. We'll read it together. A catering event is defined in the code as the furnishing of food prepared on the premise or brought onto the premise. It's referring to the off-premise that is already prepared in conjunction with alcoholic beverages for the accommodation of a person or an identifiable group of people, not the general public, who made arrangements for the function at least 30 days in advance. Okay, so just to boil that down, we're talking about a catering event being a place that you provide food with alcohol to an identifiable group of people, not the general public, and that you provide notice to the board at least 30 days in advance, 30 days in advance of that function. That is what a catering permit or a catering event is, as defined by the liquor code.
While we're on that definition for a second, Daniel, I just want to point out that it appears from that definition that what the PLCB or the legislature is trying to do is prevent situations where a licensee decides to create their own event in a field, let's say. So that's where the requirement that the catered event be for an identifiable group of people, not the general public. So that's a hurdle or a bar here that's embedded into the statute that I think is important, because what we're going to be talking about is the expansion of this act and all of these new ways that maybe we could use catering permits. But I don't want to get carried away to the point where we might run afoul of the underlying definition, in that the catered event needs to be for an identifiable group of people, not just the general public. So go ahead, didn't mean to interrupt.
No, thank you, Evan. Thank you for that commentary. That was great. Eric, if we could go on to the next slide. And I think I already made reference to who can apply for a catering permit. Restaurant licensees, hotel licensees, eating place licensees, and brew pubs, right? So if you don't have any of these licenses right now, then this is not for you. You would first have to apply for one of these licenses, and then you can get the permit. Some rules to know about permits is that if you haven't applied for an off-premise catering permit yet, this is going to be your first time applying, then you need to apply at least 60 days before your first catered event. Okay, so I know, last minute things happen, and you might have a customer that comes in and says, "Oh, we've got a wedding next week," or "Our caterer fell through, and can you come in?" You're going to. I would recommend that you apply for the catering permit well in advance to make sure that you have it, and then, if a customer does request your services, then you'll provide information to the board about that specific event. So there's also a requirement, and Eric, if we could go on to the next bullet point, there's a requirement that the licensee notify the LCB 30 days before each catered event. There's a section of the code that has the 30 days, but there's another section of the code that says that you have 14 days and to notify the board. I don't see that as an inconsistency. I just think that, my recommendation would be go with the 30 days. If you're going to have a catered function, make sure that you're notifying the board of that function at least 30 days. Don't wait for the 14 days or the 7 days. Now, what must your application to the board include? It must include the address of the location where this catered event is going to occur. You need the time. You need information on the landlord or the host. Similar to your licensed premise, you have to demonstrate to the board that you have the right to be at that location. So maybe a letter from the landlord, maybe a license agreement. And then this next one, you need to include information about your guests. Now, that doesn't mean a list of names of people that are going to be at your catered event. But in order to comply with the definition in the code of an identifiable group of people, it is important that your application to the board describe who's going to be at this catered event. This is a wedding. This is a 4th of July celebration. This is a St. Patrick's Day party and people supporting or a political fundraising event. This is a political fundraiser for Representative Nelson, right? That would suffice, but you need to include that information in your notice to the PLCB. And Eric, if we could, well, before we move on, well, that's fine, Eric, that we moved on to the next one, but Evan, I'll give you some time to comment on that slide if you have anything to comment. If not, we can move on to the next.
The only thing I'll add is that although in order to be a permit holder of a catering permit, you need to already own an R license or be a hotel, eating place, or brew pub. So that presumes you're already a licensee of some variety. If you're an unlicensed establishment, in other words, you don't have an R license or an eating place or brewery license, I think that these amendments leave open possibilities for unlicensed restaurants to have or make use of catered functions where they don't have alcohol. They may be able to have alcohol for certain catered functions, perhaps on the weekends. So I guess my point is that although to be a permittee per se, you have to be a licensee, but in order to benefit from the catering permits, everyone can benefit, even unlicensed establishments, or in other cases, private institutions. For example, we had an event at our building recently, which was an open house, and we had an R licensee cater that event. And so we were able to sort of host our event with service of alcohol to about 150 patrons using the catering license. So we are not even a unlicensed restaurant. We're just a commercial space in our common area that we had that event. So the point is, I guess, that these changes, I think, can benefit everyone, not just the licensees.
So what does it cost? What does the catering permit cost? The answer to that today is it doesn't cost you anything. And you should apply for it and make great use of the catering permit. However, Act 51 reinstated the $500 annual catering permit fee that existed prior to the last amendments to the liquor code that were adopted during COVID. So that $500 fee is not prorated. So right now we don't have the March 1st deadline that we used to have to apply for your catering permit. That's gone. But starting January 1st, 2025, you're going to have to pay that $500 to get your catering permit, and it won't be prorated. So apply early, apply at the beginning of the year, pay that $500, get your catering permit, and you have it for the rest of the year. Maybe you'll use it once, twice, maybe you'll use it 365 days a year. You don't know, but I would recommend that you apply for that catering permit early in the year. And starting January 1st, it will be $500. So Eric, next slide. Okay, so what can be sold at a catered event? You can only sell what your license authorizes you to sell. So if you have an eating place license, you're not gonna sell liquor, right? You're not gonna be able to sell liquor because an eating place license does not authorize you to sell liquor. But if you have a restaurant license, anything that you can sell at your licensed premise, you can sell at the off-premise catered event. So wine, liquor, beer, malt brewed beverages. All these drinks can be served by the glass. They can be served in open bottles, and this includes mixed cocktails. Evan, any further comments on this slide?
Not necessarily. I guess I would add that one unique aspect. I mean, if you think about what you're serving at an event, certainly you'd be limited to selling only what you can sell. But what you can do with off-premise catering permits, and I thought was a unique use of a license, specifically in this event that we had at our space. We had essentially a 2-story common area licensed to serve alcohol. So while, yes, it was a limited selection of, we picked out 2 beers and 2 wines and 1 mixed drink option for the guests, those could be served and enjoyed anywhere in the building. So it's a fairly liberal use of the license as well, where we're used to on-premises regulations sort of confining service to your 4 corners. Here with the off-premises catering, we were able to have the drinks enjoyed throughout the entire common area in the building, for that matter. Now, I don't think and we're going to get into this later, Daniel, I don't think if you're contemplating an outdoor catered function with a lot of attendees, I don't think you want to allow an unlimited set of boundaries. I do think you want to confine those boundaries. We'll get
that is correct.
In a minute.
Yeah, we'll get into towards the end. I reserved a couple of slides to get into some regulations regarding the use of the catering permit. But look, I'll go quickly in providing a brief summary of the history of the catering permit, right? So the catering permit, if we could, I'm going to give you a birth date. It was July 5th, 2012. Prior to that date, there was no sale. There was no sale of liquor, alcohol, outside of a licensed premises. You know, the rules regarding sale of alcohol to go from a licensed premises existed prior to 2012, but there was no such thing as a licensee loading up a bar or a mobile bar or bottles to be able to be placed at a bar in their truck, driving to an auditorium and setting up their bar there to be able to cater a wedding or a function. That didn't exist. So this all started with Governor Tom Corbett signing legislation in 2012. That created the permit. And I mean, I can tell you that a lot of people were not using this permit. It's been received slowly by the community, and maybe people on this call have been using it since 2012. And if that is the case, then great for you. But I have a lot of clients who I advise about this catering permit, and they're surprised to hear that they are sitting on the ability to sell liquor at off-premise events. So to all those people out there, I think it's important, all those people out there that have licenses that allow catering permits, I think it's important that you start using them. There's money to be made, and I think it could help your business. So what happened after 2012? Well, this is the next slide, Eric, but the Act 81 of 2021 was part of a series of COVID changes in the liquor code. I mean, during COVID, fortunately, we saw a lot of positive changes in the liquor code, but a lot of these changes were only temporary, right? They were designed to be able to help an industry that was affected the greatest by the pandemic, the COVID pandemic. And so the legislator and the governor got together and, they were able to adopt changes to the liquor code to expand the use of catered permits. So what Act 81 did is that it removed the limit of 52 catered events per year. That's what, when the governor signed the law in 2012 and created the catering permit, it was limited at 52. And maybe that's the reason why a lot of people didn't use it, frankly. Maybe that's why, because 52 events, that means that you can only cater on the weekends, if you do the math. But so Act 81 lifted that number and said, okay, you can cater an unlimited number of events. There was a $500 fee that I mentioned earlier. Well, that was waived, right? That $500 fee was waived by Act 81. And there was a limit on the duration, a time limit on the duration of a catered function. It was 5 hours. A catered function catered event could only last 5 hours. And Act 81 extended that to 6 hours. And lastly, previously, there was a requirement that licensees apply for their catered permit no later than March 1st of each calendar year. Act 81 eliminated that March 1st deadline. So this brings us to the present, Act 51. what Act 51 did is that it confirmed, right, or made permanent a lot of the changes to the liquor code that were temporary under Act 81. So Act 51, and if Representative Nelson is still on this call, I tip my hat to you again. Thank you for your efforts and bringing this piece of legislation into law. But it was signed by Governor Shapiro on December 14th. And what it does is that it removed the cap on the number of catered events that you can have per year. It's still unlimited. And it does reinstate that $500 annual permit fee starting January 1st. But I'll say it again, right now, there is not a fee, so you can apply for your catered permit at no cost. It keeps the extensions of the duration of a catered function at 6 hours. And it also removed that March 1st application deadline. Okay, so those are the great things that Act 51 did for our industry. Now I'll get into some more nuts and bolts about the catered permit. If you're going to apply for a catered permit, I'm sorry, once you've applied for the catered permit and you want to then host a catered event, you are required to provide advance notice to the PLCB 30 days before the catered event, and also provide notice to local and state police 7 days before this event. Now, if you provide notice less than 14 days, but at least 7 days before the event, the PLCB will charge a $100 late filing fee. And that's why I say you stick with the 30. You know, don't live within that time frame of 14 to 7. I would just go with the 30 days prior to the event, and 7 days prior to the event to provide a local and state police notice. Now, the duration of a catered function is 6 hours, and you have to end. It's 6 hours per day, and you have to end your catered event by midnight. The only exception is on December 31st, in which case you can have your catered event up to 2 a.m., right? And those are standard hours for restaurant licensees, right? 2 a.m. is when you have to stop serving liquor. Now, all your servers at the catered event have to be ramp certified, okay? So this is not very different than what you do at your licensed premises. Make sure that your servers that you're taking out to this off-premise event are ramp certified. Also, just like, you know, the same rules that apply to your licensed premises will apply to this off-premise catered event. And that means that your customers are not allowed to remove alcohol from this off-premise area.
Just to zoom in on that real quick, Daniel, I saw a question pop up, and not to jump out of order with the questions, but I think there was a question about whether you can sell 6-packs to go or wine within a wine expanded permit from a off-premise catering location. And the answer is no, but I think that that's an important difference between what you can't do at a catered event, but you can sell wine to go or 6-packs to go from your bricks and mortar location. So that is an important limitation. It doesn't allow you to prop up a to-go store, unfortunately, but it does allow you to sell pretty broadly to that identifiable group. But go ahead, Daniel. I just wanted to pop into that little clarification. And
Well, I'm glad that you added that and answered. You said that was a question from one of our listeners, right, Evan?
I think, or I made it up.
Thank you.
I don't know.
Okay, thank you. I think our slides are a little bit out of order right now, Eric, right? But
Trying to get this back something here.
that's fine. I do remember what the last bullet point was. So I'll just I'll get into that while oh, there it is. Oh, wow, that was quick. Thanks, Eric. Thanks. So the last where we left off was that licensees are allowed to transport alcohol to and from their licensed premise. As you know, as licensees know, the general rule is that you cannot transport alcohol around town without a transporter for hire license. And those transporter for hire licenses, I think they became very popular during COVID when licensees were doing a lot of food delivery, and then cocktails to go were still in place. And, you know, you could also sell the 6-packs and the bottles of wine. So I remember seeing a lot of clients apply for transporter for hire licenses to be able to get the alcohol from the licensed premises to their customers. Well, you don't need to do that for catered events. The liquor code already gives you the license, if you may, to transport the alcohol to that banquet hall and back to the restaurants. If we could go to the next slide, Eric, thank you. There is a restriction on where these catered functions can occur. You cannot have a catered event at a place that is already licensed. And then why would you want to do that, really? I mean, I could think that maybe one reason you'd want to do that is that your license is expired, right? And you say, okay, my license expired. I want to have a catered event, and this way I can continue to sell alcohol at my restaurant. You can't do that. That's a prohibition there. How about if you've applied, this is a new restaurant, a new premise, and you've applied to transfer a license, this new premises, and it's been 4 months, it's been 5 months, you know, you're way behind opening date, your opening date, and you just want to start serving alcohol at your new restaurant. Unfortunately, you cannot use your catered permit from your other restaurant to be able to have a catered event at your new restaurant, because there's already an application that is pending to license your second restaurant. So there are two important prohibitions there. So alcohol can only be provided during the days and hours that the licensee holder can sell alcohol. So, you know, just think about the rules that you have to follow at your licensed premise. I mean, did you apply for the Sunday sale permit? Did you or did you not? Do you have the wine expanded permit, right? I mean, think about what you have to do at your licensed premises, and then, you know, the same would carry over for your off-premise catered event. This is an interesting one, and I'll start off by saying that the board, you know, this catering permit has been around since 2012, as I mentioned earlier, and the board has not, they haven't written regulations or extensive regulations on catered permits, or on the use of catered permits. There are some advisory opinions and there are some letters that the legal department has issued, but we don't have a set of regulations in place for catered permits. So the code is very, very clear that you cannot have a catered event in a parking lot at a sport or a concert events. What are they aiming at? Well, they don't want you to use your catering permit to tailgate. That's really what this is after. So what does that mean? What's the size of the parking lot? How far does the parking lot need to be from the stadium? I don't have answers to that, but I would just say use common sense until the board publishes regulations. Just use common sense and don't agree to use your catering permit for tailgating. Yeah, so I think I already made reference to this one. You cannot use your catering permit to add a location that is, you know, where there's a pending transfer application. And I'll also say because you have to notify local police and of course state police, and the state police are the ones that enforce the liquor code. They're the ones and they're aware of your catered event, right? So going back to the prohibition of tailgating, or using your catering permit for a tailgate function, you know, you don't expose yourself because they'll be there and, you know, they can say, you know, you can be in a field that isn't clearly marked off as a parking lot, and they can say, look, I'm going to issue you a citation for having a catered event in a parking lot. And that's the way it's going to go, right? And then you'll have to take that to an administrative law judge and make your arguments. But that's an important one to keep in mind. I mean, state police and local police will be notified about these events, and they will be making those judgment calls in the field. And an important one, this is an important point to know. If you are catering on private property, the state police has the right to access that private property to see if ramp rules are being followed and the variety of rules that are in the liquor code are being followed. And that is, I think you want to tell your customer that, you know, they, by hiring your services and by you catering an event on their private property, they are opening the door for the state police to enter their property, right? And that the general rule is that, you know, the state police is only going to access private property with a warrant, right? And there's got to be reasons for a warrant. You know, there's the Constitution that protects us and criminal procedure that protects individuals. But, you know, if you're going to cater an event on private property, you are opening the door for the state police to be able to access it. So,
hey, Daniel,
go ahead.
While we're on this particular slide, at this bullet point, I noticed in the comments a second ago, there was a comment about local law enforcement being notified and having no clue what the licensee is talking about with regard to having to notify them about a catered event, sort of falling on deaf ears with local police, and then not necessarily knowing the right procedure to notify state police of the matter. And I guess my recommendation there, I can't say don't notify the local police, but it's a requirement. I guess you just have to do the best you can. And to the extent that you can, get these things in writing by way of email or sending a letter to your local police. That way it's not a he said, she said in the future.
Good point.
And with regard to, that's the litigator mindset. And with regard to the state police, I think that you would probably want to focus in on the Bureau of Liquor Control Enforcement, which is a subset of the state police, because they will know about these permits and the requirement to notify them, and the just state police at large, that may also kind of fall on deaf ears. You may have different experiences because as the attorneys here, we're rarely in the position to be applying for the permit and sending notice to the police. So I don't have that firsthand knowledge that you may. There may be some assistance gleaned from some of the comments, which I'll share if I see any of that. But I just wanted to add that you got to do your best, and to the extent you can, having a paper trail of that notice to the BLCE and local police would be advantageous.
Yeah, thank you, Evan. Yeah, after you provide that notice to the board, and you get confirmation of the receipt of the notice that you sent in, the board will also provide a form, a state police form that you can fill out and then submit to the state police. And you're right. I mean, the Bureau of Liquor Control Enforcement, state police, is the one that has jurisdiction to enforce the liquor code and its regulations. So they're going to be the point people. But I can tell you, I mean, let's not ignore the locals completely. Even though they don't have jurisdiction to enforce the liquor code, there might be a local ordinance. And I think that this is a very fact-specific situation, but you might be in a municipality, you might be in a city, you might be in a township that has a local ordinance regarding serving of liquor in any area within that municipality. So just check the local ordinances. It would be my recommendation, but certainly without fail, you want to provide that form to the Bureau of, to the state police, you know, the Bureau of Liquor Control Enforcement. And then for the local level, well, that's just on a case by case basis. So, yeah, it's not, I think there was a question about, do you send the approval permit that we get from Loop to state police? It is not the approval permit itself, but there is a separate form with the logo. There's a state police logo on top. It's a one pager. It usually is attached to the approval permit that you get from the PLCB, but the approval permit says PLCB on the top, and it's one of the attachments. So just go through the packet that you get. So, well, hey, that's what I have. Evan, I don't know if you have any further comments, but I think at this moment we'll probably take some questions if we still have time. Eric and Zach, I'll take your lead on how you want to handle this, but as far as our presentation goes, I think we've come to a close at this point.
Yeah, thanks.
Thank you both very much. Great presentation and really great work there. We do have at least 9 minutes left. We typically run these for about an hour, and since they're recorded, we could always go overtime if necessary. I was working my way through the questions. I think you guys did a really good job of handling those as they came in. I know you guys kind of expanded on the questions related to local police and state police. I don't members, please feel free to chime in if there's anything we might have missed. In the meantime, my question for you guys, Evan and Daniel, is just in your experience, and I know you've probably already been talking to owners and operators about this, in your experience, and you alluded to this a little bit earlier, but where would you say are the what's been most confusing based on the temperature check you're getting from the industry? Is there anything that's really tripping people up?
That's a good question.
I think that the availability was a hurdle, but then the secondary hurdle is like, how can we really use this? Because I think that most licensees will default to the catered wedding as the format that these all have to take the form of, and they think, well, I'm not doing any weddings anytime soon. I'm just a corner bar, so it's not for me. And I think what this does is it enables a restaurant or a bar that may have limited capacity inside. You may only be able to serve 100 people per night at your location. But now if you have the employees to pull this off, you could have 5 catered events going on in addition to your service at your bricks and mortar location, and quadruple your income from off-premise events now that these changes have taken effect. I think that the previous limitation of 52 made it seem as if it was dispreferred by the PLC. We don't want this to happen a whole lot. We're just going to give you 52. And it really put a damper on the catering companies, those companies that wanted to do maybe 5 events per weekend, because they would max out in the middle of the year. They wouldn't be able to do events all year long. But I think that the details of what you can do has been one of the limitations. And I think now that we have these expanded permissions, what I'm hoping to see is more of the non-traditional use of the catered permit to do happy hours or to do like a pop-up event in a city atmosphere or in a more rural atmosphere. So to kind of get out of that catered wedding mentality into a more versatile use of these art and other retail licenses.
My mind is racing there. I imagine others are as well. Ben, did you have a question? See, Ben Felicia from the PRLA team has his hand
Hey, good afternoon. Thank you. That was that was a really great webinar, and I plan on watching it again when I get the recording. So I had a couple questions, and to what you were just talking about, how we hope to see unique uses of this. So 2 questions there. One of the qualifiers was I forget the terminology. Maybe Evan, you can help me out with that about the identifiable group of folks that are invited. It has to be an identifiable group. Is that the terminology, or?
That is the correct term. That's straight from the definition. Identifiable group of people, comma, not the general public.
I mean, could that be, I would love to see some beer gardens pop up. Could that be the identifiable group? Could it be my neighbors in South Philly? Could it be, I'm in Durnley Park section of Philadelphia. Could it be the Durnley Park neighborhood? Could it be if I started a Facebook group that was fans of beer gardens, and if you were a member of this group, fans of beer gardens, would you then be would that be identifiable group to attend my pop-up?
It is an identifiable group. And I also am curious to know when we had our event here, what that identifiable group was, people who are
Customers of Tucker Arensberg. Customers and friends of Tucker Arensberg. Yeah.
I guess what I would advise a licensee, I mean, what you've put your finger on is like, how far can we go into being pretty close to just the general public definition before they're going to push back? And before I would allow you as a client to submit like fans of beer gardens as the identifiable group, I might suggest, like, is there a Friends of the Wissahickon or a horticultural society or a dog rescue that we could wrap into this to kind of make it a little more legitimate as far as our identifiable group? But, we did ours here, and I'm not saying that we necessarily passed PLCB scrutiny either, because there was no scrutiny. But ours was just a happy hour.
Yeah.
And it was clients, potential clients. It was other tenants of other of our landlords' buildings. So we got pretty close to general public there, I think. So I think you just have to try to do your best to find that identifiable group so that you don't give them that reason to deny the permit. Because if you just say, we're going to have a super fun event, you just need to get behind this, you just give them a reason to deny the permit because you don't have an identifiable group.
Okay. So I'm going to give you, I guess, another example, because I think she may be on the call. The Roxborough Business Improvement District has a pocket park right on Ridge Avenue, and they would love to have a beer garden on the weekend nights in the summer, Friday and Saturday nights. And but they, I think they probably have a Friends of the Pocket Park, that I'm assuming that could be the target audience.
So here we get into, so this presentation was pigeonholed to discuss the catering permits. So we start to get into these other overlapping permits. Something like Business Improvement District might be able to take advantage of a special occasion permit where they are the permittee and they're able to sell the alcohol and they don't even need an R licensee involved. And then you get into, on the other side of things, when you talk about beer gardens are typically manufacturers, not retail licensees hosting beer gardens. It's the manufacturers. So they're making use of their expo permits, which is another variety of these permits that are unique to manufacturers. So depending on what event you want to do, we've got some resources in our quiver to go through to figure out what the best idea is. We're at the very front end of helping a local municipality who wants to have a like a street festival. And so far, the email requests to me has a lot of incorrect legal conclusions about distillery licensees being able to sell their distilled products and beer to go and walk right out the door with it. And they're asking questions like, how can we have this street festival and allow these two manufacturing licenses to be like the hosts? And I think we just need to retinker the way they're thinking about it right now, because they can't just have these people spill out onto the streets from these two manufacturing locations. We need to either create a catered event, or we need to create a special occasion or an expo around this event that will try to rein that in. I don't know. Did I dodge your question or answer it?
No, it was perfect. It was a perfect attorney answer. I love it.
Yes.
Thanks, Ben. There's two questions I want to get to. There's a question about who needs to be ramp certified at these catered events. And the answer is it's people who are serving the alcohol. I think if you just have somebody picking up empty glasses, they don't have to be ramp certified. There was also a question about, do you have to provide the food, or can you just bring the liquor and have somebody else bring the food? And I think the answer to that is that, yes, you could team up with somebody else to provide the food, just as long as you do fulfill that that requirement that is in the definition of a catered event, which says that you have to furnish food prepared on the premise or brought onto the premise, and that food is served with alcohol. So I think you could pair up with somebody else to be able to meet that requirement.
Daniel, Evan, thank you both for going through those questions. One earlier, and forgive me if you did get to this already and I just missed it, but there was a question related to catering at a restaurant that doesn't have a license. Is that?
Yes.
Any
I love the idea. As long as they don't have an application
Yes.
to get a license transferred to them, it can work.
Mhm.
You might need to think a little bit about the identifiable group. I mean, in other words, would patrons of unlicensed restaurant be an identifiable group? I mean, it sounds like an identifiable group, but you could also argue that that's just the general public. So
I think the Act 51 changes are really going to test this definition, Zach. So we'll be, stay tuned is what I would say. Stay tuned but I think that there are a lot of arguments that can be made to be able to expand this, the meaning of what an identifiable group is. Can a licensee with a catering permit in one county cater an event in another county? Answer is yes. The answer is yes. Somebody in Allegheny County could cater an event in Butler County, Westmoreland County, Erie County, Philadelphia County. So yeah, you're not restricted to the county where your license is issued.
that really opens up a lot of possibilities. I mean, there'd be work involved for sure, but you could be in, let's say, Washington County and cater large events in Allegheny County because you don't have the population in your local municipality and your license is limited to that county, but your permit's not. Your off-premise catering permit could open up opportunities all over the place, including at unlicensed restaurants. So yeah, there's no end to the possibilities. Some other ideas that I think I have to give Zach credit for this one was sort of rooftop happy hour pop-up functions. Let's say PRLA wanted to have a fundraiser or just one of its regional chapter events. You could have a catered event, I'm sure you already have, at a rooftop deck. It doesn't have a bar. It doesn't have a licensee on premises. You could start taking locations that don't already have food and alcohol resources and turn them into viable venues.
Right. There's a question about the need to provide food at a catered event. The answer is yes, you do. And that stems from the definition of a catered event in the liquor code that says it's the furnishing of food prepared on the premise or brought onto the premise, already prepared, in conjunction with alcoholic beverages.
Right.
Okay, so I think that we cannot dodge that food requirement.
Right. But as most licensees probably know on this call, you can satisfy that with hot dogs and soft pretzels.
Correct.
So it's not really an insurmountable problem.
Doesn't have to be a Michelin star restaurant. Understand?
That's correct.
Mm-hmm.
And you guys did note earlier that, or forgive me if I got this wrong, but certain types of parties could potentially be listed as an identifiable group. For instance, a St. Patrick's Day party, or
Yes.
Easter brunch, or etc. Gotcha.
It
Political fundraiser. I think friends of Representative Nelson, a political fundraiser, an ethnic group, a Cinco de Mayo celebration. If you can identify a group of people that have something in common, I think Evan mentioned dogs, right? Dogs, horse show, car events, car classics, sport. Sports is an interesting one because you can't tailgate. You cannot tailgate, but
I think this question of the identifiable group becomes more important where the licensee is trying to prop up its own party. I don't think you have the identifiable group problem if you're catering an event for a customer. Your customer is your identifiable group. You're doing this event for Tucker Arensberg's happy hour party. But if you're a licensee and you want to it's not just for a client, but you want to create the event that people would come to. I think that's where we need to be just a little more careful that it isn't just the general public, that we do have some identifiable group targeted for that event. So I don't know. Have we lost everyone yet?
No, I think we've still got a few people hanging on. However, I want to be cognizant of your time as well. I know you both are very busy. We appreciate you being here. I will pause for a moment and give folks an opportunity. If you have not already, you'll see Daniel and Evan have generously shared their contact information with us. That should be on your screen right now. You know, I don't want to volunteer them, but I'm sure, as you guys know, they're very resourceful on this, and I imagine they'd be happy to chat offline if there's any specific questions or concerns that come up in the future. Evan, Daniel, if it's helpful, feel free to throw any contact info you want in the chat, of course, and appreciate your partnership on this. I'm not sure. I think we've covered all of the questions. For those in the chat, sorry about the confusion related to timing. Like Lauren noted, this webinar was recorded. It will be sent out and distributed to anybody who registered for it in its entirety. Lauren, Ben, Evan, Daniel, any closing remarks?
I just wanted to say thanks very much to Evan and Daniel. This was super helpful for everyone, and we really appreciate your time this morning.
Thank you.
And I just want to say, when you, everybody on this call, when you receive your recording of this call later, please share it with your friends, share it with the other members, share it with the other caterers. Dominic, let's make sure that we get this out to all the caterers on the catering council. It's really important. This is a lifesaver and one of the best pieces of hospitality legislation that we've seen in a very long time. So let's make sure we're using it.
Yep, my closing comment is go out there and use it. Use it and use it often. And the PRLA team, you guys are amazing. Thank you for all you do. And thank you for allowing us to share a platform with you today.
Yeah, absolutely. Thank you.
Daniel, Evan, thank you very much. Thank you to the entire team at Tucker Arensberg. Thank you, everyone, for joining us. Recording will be out shortly. Have a great week.